Thank you very much. My name is Chuck Scolding and I'm from Bracknell Forest Council. Now, earlier I think we discussed about consent, and maybe local authorities don't need to use consent. However, I think, David, you mentioned a bit about consent as well. Maybe I'm wrong. I'd like your explanation, is it okay?
What would you like explained?
The actual whether or not councils could use consent, or should we just stay away from it because we have the legal obligation, we have public tasks?
That's certainly the direction we're talking to the health service about, that consent for GDPR standard consent is very high. It gives individuals extra rights in terms of the right to be forgotten, in terms of portability. And we have a juggling act as well, because, as I mentioned, we have to consider the common law duty of confidence, where you have to, that's consent-based. And our approach, and it hasn't been thwarted yet by the lawyers, is to separate out consent and have an approach that goes, you get consent for the common law duty of confidence. So if you're not delivering direct care and you want secondary use, you get that consent. But what you then do is look for an alternative basis under the GDPR. Is it, if you're private sector, legitimate interest, lawful authority, public interest, etc. But you get that and you keep that separate because the GDPR is such a high standard. And the other thing that say around the GDPR is that where the relationship is between a public authority and an individual, because that relationship is loaded basically in the favour of the public authority, you shouldn't use consent. You should use one of the other conditions that can be relied on. And that's the approach we're taking across the health service, that unless it really can be justified why you will want to use GDPR standard of consent, don't. Use the other means. And what we're saying is, but be clear with people, be transparent with them, etc. Just be very cautious about your use of consent to satisfy the GDPR.
Chris, do you want to just mention, because you pointed out in your talk that in your view, the use of consent is not really viable, in your opinion, for public sector organisations and local government. Maybe you can just say why and what you think.
Me? Okay. Right. I thought I said Christine. I thought, oh, God, all right, I can back out of that one. Okay. Right. Why? It's very easy to say, right, you're my GP and I refuse treatment. Okay? Should you keep records of my refusal?
Yes.
Now I say I'm withdrawing consent for you to keep records. And can you rely on consent? So you've got to find something else than consent. All I would point out is in Schedule 3, Schedule 3, some people think I'm a lunatic. Right, okay. In Schedule 1, paragraph 2, there is a specific condition for health and social care purpose, which isn't a consent purpose, and that is occupational medicine, medical diagnosis, provision of healthcare treatment, provision of social care, and management of healthcare systems. And I don't think the government would have given you that if they're saying consent is the best option. Yeah, so it's necessary for your functions. What I think the Caldecott Guardians have done is separate out consent for treatment, which is perfectly reasonable, and they've conflated, I think, consent for treatment. Sorry. That was my reminder to come into the room. So, as you can see, I have a sophisticated ringtone. Right, okay. Conflated consent for treatment and basically consent for record keeping. And I don't think you have consent for the record keeping. You must keep records of what you've provided. And it can't be consent, end of.
So are you from a local authority? So are you delivering social care? Yes. Right, so in simplistic local authority terms, currently we work with consent for adult social care, don't we? Okay, so if you are talking about simply a legal basis for processing, we won't be using consent, you'll be using 9(2)H, excuse me, as Chris said. However, word of caution here, you can't just say we don't need consent, because the minute you do that, the walls fall down. We still have to satisfy the common law duty of confidence, and that's what your consent is for. In its most simplistic form, because the difficulty is trading out to your social workers and other staff, I get that. So the way I think it's probably easiest to look at it is you don't need consent to process that data, but you need consent potentially to share it. So get consent, explain what you want to do, everybody's happy. Yeah, make sure your record keeping on ROPA is accurate, that you do use the right legal basis. Yeah.
We're going to try and get everyone on the panel to say something on this question. I'm just going to add, so it's you after, Stacey. We are going to cover some of this in the health and social care session later, talking about consent. So if you want to explore this in more detail, we're going to be talking about that later.
Next question.
David Roper-Newman, Craven District Council. I was just going to follow that question because in terms of a lot of the processing activities that local authorities do, they are statutory, for example, housing benefit assessments, council tax, etc. And as Chris has said, people don't have any choice about that side. But we've got a lot of what I describe loosely as fringe activities, such as marketing, sending out newsletters, etc., which I think probably we'd need to be aware of the requirement for consent in that area. And I think, you know, in my own council, we have sports development, and we've got lots of people who subscribe to cycling club newsletters and all this sort of thing. And those are the sort of fringe activities that I think you need to bear in mind if you're doing those things. You know, people who subscribe to our leisure centre newsletter and so on, they're again not our statutory functions, I would suggest. And we need to be a bit careful about that. And those are the areas that I'm looking at the moment in that respect.
Thank you. Jeff Gray, Lewisham Homes. I'll back up the person who mentioned there for the local government side of things. You will need consent if you're going to do marketing. It's totally different from what the organisation is set up for. But that's not my question. I feel I'm quite on the way to getting ready for it all. The only question I have in my mind is the significance of a breach. Now, I use the toolkit as well, so I use the toolkit as a scoring on that. Now, two questions then, I suppose. Is the health service going to do a rescoring of that for the significant breach? And will the Commission actually look at that to give some guidance on what a significant breach actually means? Otherwise, you're going to get lots of reports coming through because no one knows the boundaries.
In terms of a significant breach, what is that referring to? What's said within the GDPR? Yes. Because it's I don't think the wording is quite significant breach. It's, and I should know this because I'm doing a workshop on it later. Yeah, there you go. Come to my workshop later. I think it's more around where it's high risk, where it's likely to result in a high risk. And then I think when you have to report it to individuals, it's, sorry, I'm getting confused. So it's when it's likely to result in a risk is when you have to report it to the ICO, and when it's a high risk is when you have to report it to the individuals. There we go, I got there in the end. So we have actually produced some guidance around sort of the risks to processing, and this is something that I will discuss in my workshop this afternoon. But I'd probably point you in the direction of the Article 29 Working Party guidance. There's quite a useful few points in there around that kind of risk assessment process, which is going to be needed to obviously assess that risk. And I think they also provide a sort of common methodology. There's a link to like a methodology that you can use in there. In terms of the specific questions around the toolkit, I'll pass that one over to David.
Thank you. Start with the toolkit. That has been substantially replaced, I think, this year. The feeling was that the old toolkit, which has been in existence from about 2001, 2002, had become inflexible and rigid, and the worst point of view, certainly from the health service practice and feedback, it could be gamed. And I certainly had that feeling from my time at the ICO, where we saw organisations submitting very good toolkit scores and then being caught out when they had to report the security breach to the ICO, and the investigation found that their practices were a long way from what they recorded in the toolkit scores. So there is a replacement for the toolkit which focuses much more on information security. In terms of the standards, we have to, and we've worked with the ICO on this before, there is a level somewhere that goes, this is reportable, this isn't. That's yet to be defined in terms of where it fits with the new toolkit and also with the GDPR. But Stacey's advice is right. It is, where is that risk? So where there is risk of damage, detriment, harm to individuals, that's the ICO. Where it's significant risk, that's the individuals as well as the ICO. And again, as I said, you may not have specific guidance that gives you an immediate clear-cut answer, and certainly at the moment, certainly in the early doors, your professional experience will count. So if you think that the data breach will not end up as a risk, then that's your decision. But again, as I said earlier in my presentation, justify it. And vice versa, if you think it will be a risk, justify it. Why? What type of data is it? Where could it have got to?
David, could I also add to that? So there's also a publication, Department of Health and Social Care published an updated paper last week on the new Data Security and Protection Toolkit. Have a look at that if you're a local authority delivering social care or public health services. There's a specific section in that guidance or in that toolkit or in that report that talks about local authorities and also talks about if you're a care provider as well and what that means. So I encourage you, if you are a local authority with social care public health, do have a look at that publication which came out last week.
Hello, I'm Natalie Boateng from Broxbourne Council. It was mentioned earlier that we're going to have to renegotiate all our contracts. I was wondering if the ICO will be preparing some model contract clauses incorporating the requirements under GDPR to assist local authorities.
We've been working since the summer with the Crown Commercial Service on this, and they in fact published a procurement policy note just before Christmas, which did exactly what you asked. And it gives sample clauses and guidance and advice on what you should be doing with new procurements, new contracts, and indeed what you maybe should do in terms of anything that's already in place and in existence. So if you haven't got the link to that, we can happily send it to you later. Contact us on the email address transparency@local.gov.uk. Just a quick plea, actually, and a mention, an advert. There's a knowledge-sharing group on the Knowledge Hub that started in July last year, now has about 700 local government registered users, and that's been a wealth of places and source of information where questions and answers are being made, and we're helping ourselves as a sector. And organisations are uploading policy documents, job descriptions, sample processing agreements, sharing agreements and so on for other councils to look at and use or change and use. And there's a wealth of information there. So I'll give you the link to that in the next slide or two, but be aware of that as well.
Lynn Wyeth from Leicester City Council. I just want to go back to the data breaches, Stacey, if I can. Very topical for us, if you saw us in the news a few weeks ago. I just said, don't believe everything you read in the paper or on Twitter. A lot of questions I get asked when I'm going out training is people are aware of the sort of requirements to report, they're getting their head around when they might have to report. I think that, there's lots of guidance out there. What we've not had yet is how you're going to facilitate that. And I wondered whether the ICO could tell us when we'll get guidance about how we're actually going to report to you. Is it going to be a telephone line? Is it online? I think people are quite worried about the resource. And also for you guys, I saw this week that you estimated you might get about 30,000. I think that's an underestimation personally, because I think you're going to get over reports. You're going to get incidents that aren't breaches. You're going to get people that are reporting things that aren't really a risk at first. So do you know how you're going to do it or when you can tell us?
Yeah, and again, it's something that I cover in the workshop this afternoon, but we've been piloting a telephone helpline for a number of months, and this is actually live now, and I do have the details if anyone wants that, but again, they're all on the slides, my workshop slide is. And yeah, I think we've been given similar thoughts around how we can actually anticipate the numbers, because it is a new requirement for us as well. And I think we've got similar concerns that, it's going to open the floodgates. And I think that's why we've been trying to run this pilot. And I think there has been a kind of soft publication of it, but we've been very careful, obviously pre-GDPR, to really kind of publicise that and open the floodgates too soon. So I think we haven't had that many reports from local authorities. I don't think awareness across local authorities is sort of there about the helpline at the moment. So something that I mentioned in my workshop in Manchester, and I'll mention again today, is that if you are wanting to report a breach and you think it would fall within those kind of requirements of reporting a breach under GDPR, then by all means use the helpline to do that as almost kind of like a pilot for yourselves. The website form is also still there, but I think we're really going to be trying to take the helpline option forward and gain some more momentum with that over the next couple of months, because it gives people that opportunity to speak to somebody straight away. If you're not sure whether to report that breach, you can obviously speak to that person straight away and get some immediate advice and guidance as to, you know, what further information might be required, or, you know, whether it's even one that we would want to have reported in the first place. And then there's some wider guidance on our guide to the GDPR on the website that supports that as well.
Hi, my name's Oliver Dixon. I'm the Data Protection Officer for Eastbourne Borough Council and Lewes District Council. I guess a lot of people in this room, after today and for the next 4, 5, 6, 7, 8 months, have got the task of communicating the GDPR message to a lot of people, a lot of officers, a lot of members, a lot of senior managers. I'd be interested in the panel's any sort of good practice or ideas you might have about getting the GDPR message across to perhaps non-data protection experts in a sort of stimulating, engaging way. I mean, it's easy for us because we're GDPR practitioners, but let's face it, 95% of our organisations are not, and you know, typically already people can see that it's sort of important, but it's quite difficult to get people really sort of motivated and enthused about the subject. So I'm very much open to ideas about how we can get that across.
Whilst the panel's thinking of the answers, I'm sure they'll have something to contribute because some of them are doing it already. I'll sort of start by saying a number of things. This knowledge sharing group I mentioned, there are some examples of materials and plans and presentations that have been prepared to suit exactly the audience that you're describing. So you can maybe go there and see what others are doing in the local authorities. Secondly, I mentioned that there are a number of e-learning modules in development. The LGA is preparing one for councillors, and that should be ready, certainly we hope, by Easter, which is done in such a way that it will sort of enthuse them and show them the complexities of being a data processor as a councillor, because they're not only data processors in their own right as they're receiving case notes and communications from their constituents, they're also representing their political parties, they're also representing their organisation. So there's a whole raft of complexities there, and we're putting together some material there. And thirdly, we're conscious that a number of authorities are preparing e-learning modules for officers and staff. And whilst we're not doing anything like that in the LGA, we are in communication with those organisations. And some are saying we're happy to share those more widely and probably freely available. So we'll be keeping you informed of how we go with that. But there may be some examples there for you to use. But I'm sure people at Laurie will have definite views of what you're doing in Essex, for example.
Yeah, I mean, I don't know that there is a one-size-fits-all necessarily that will fit everybody, but I can share what we've done at Essex. So about 18 months ago, I wrote a presentation for our senior leadership team, Chief Exec, explaining what those laws look like and what its impact might be on ECC. They don't want all the detail. They really haven't got time to be worrying about that. All they want to know is, how is this going to impact our organisation? What are the broad strokes? So we did that first and got that senior leadership buy-in, because that is critical to anything that you want to do in your preparations. If your senior leaders aren't on board, it's going to be tough. Okay, so you really do need to make sure that you've got them on side. Once we'd achieved that, we needed to work with the business to create a records of processing activity. So that was some general awareness for the whole of the staff through our intranet, through targeted emails to line managers. We also done targeted training for what we call our specialist groups. So obviously the information governance team, our contract management team, people that are going to very early on be quite heavily affected by GDPR. We've realigned our e-learning module for information governance. That's been taken down because we're aligning that back to GDPR. That will go back up ready for staff. But we have a communications plan that means every 2 weeks there's a message going out. so that we're not flooding the workforce, but we're drip feeding, we're reinforcing, they're slowly getting those messages. But I think what I would say for local authorities, it's one thing getting your own staff on board and training them, that's critical, I know, but don't forget about your suppliers. Yeah, if you're writing it in-house, it would make perfect sense as we to share them with your suppliers, because they are also on this journey and their risk is your risk and vice versa. So try and think a little bit wider than your own organisation and support where you can.
Jeremy Lilly from Tech UK is running one of the workshops this afternoon exactly on that subject. It's engaging with the suppliers of your data processing contracts and your IT systems and what they're doing in the technical community to help us and how we can work back as a partnership and help them.
I'm Catherine Shopflin from London Borough of Hackney, and just interested in terms of the kind of engagement and communication, the extent to which you're going to exploit the current interest in GDPR and use that as a badge, or the extent to which you want to emphasise that this isn't about a one-off thing in a panic, it's about a long process which we should all have been doing already anyway.
Yeah, it's very much the latter. We're not interested in a shock tactics that, you know, we're all going to get a horrendous fine. That, as Stacey said, there is no point to that. There's no value in scaring people. This is about, look, we are reasonably good at the moment. However, we're going to have some new processes come in to make sure that we can fully meet these. These are what they're likely to be. If you're going to be impacted, clearly we're going to be coming to you in a face-to-face training session anyway. For everyone else, it's just awareness. But data protection is not just for Christmas.
Hello, Mario Leo from Runnymede Borough Council. Just 2 points. Firstly, with regard to staff training. The message I found when you started the training is if you asked people in the room how many of them had store loyalty cards, such as Tesco's, Waitrose, and then reminded them that basically GDPR would apply to them, it suddenly perked up interest in the room. And I think it was a question of saying that GDPR wasn't just work orientated, but it was in their personal life. And I think that seemed to get the message across, and suddenly it was, no, this isn't just a work orientated thing. From a question point of view, obviously local authorities have had document retention schedules for a long period of time, and they're used to managing documents. But clearly, from a GDPR perspective, sometimes it's the personal information contained within those documents. And there can be an argument of which retention period really applies. Do you have regard to GDPR in the sense of only holding that personal data for as long as necessary, or do you look at the document? Is there any kind of guidance, or is it just a question of a balancing exercise?
Again, can I start? And I'm sure that maybe Chris or Stacey or someone will have a comment as well. But in the LGA, you may be aware, we have a number of digital tools that we've had available and provide to the local government sector on this very subject for some time. So, for example, there in the LG Inform Plus package, there is the record retention tool and the links to the powers and duties and legislation. So for every service we deliver, and there are over 1,000 in local government, we know what the law says you should be doing for those services, and whether it's a power, that's a discretionary objective, or whether it's a duty, you must do it. And we also have a document related to each service, what documentation you should be holding, and indeed where the personal data should be held and where it will be collected for those services. Now, it's not exhaustive, but nonetheless, in our tools, we know we've got the rudiments of helping with the ROPA, the record of processing activity. So we're developing at the minute, and hopefully by Easter we'll have a first version. There will be an ability to look at what's already within the core database of these services for every service, what documentation is held, where the personal data is related to it, what the schedules are according to law for those things. And so you'll be able to develop a baseline ROPA, a record of processing activity. It won't be perfect by any means, because you really must then go through each line and say, no, is this right for us? Do we have any local policies? And check it through your legal department. But be conscious of that sort of thing that we're doing to try and help. But it is ultimately open to the discretion of your legal department and the policies that you put in place in local government. Anyone want to add to that?
The law around retention, as you point out, is quite generic and not very specific. And therefore, obviously, for that reason, the ICO guidance is quite broad and, again, non-specific on that issue. I think sectors themselves know the reasons why they need to be processing that information and the justifications that they've got for processing that information. And if you can, obviously, justify that and you've got that justification there, then I don't really think we would have any other opposing argument to that, given the broadness of what it says in the legislation.
Chris?
Just very quickly, the question, should we say, assumes that the retention criteria for the document is different to the retention criteria for the personal data. The principle basically says personal data kept in a form which permits identification of the data subjects for no longer than is necessary. So if it is necessary to keep the document, the chances are it's going to be necessary for your legal or public tasks to keep the personal data. If it isn't necessary to keep the personal data, you could get to the position of, say, kept in a form which permits identification of data subjects for no longer than necessary, just basically de-identify the bit that relates to the living individual, and that would sort it out. Now, you might get this with, say, press releases. You know, you might have a press release that sort of says Mary Smith of 55 Acacia Avenue has been prosecuted for benefit fraud. Yeah, she's now doing 10 hours community service or whatever it is. Yeah? So how long are you going to keep that press release in an identifiable form? So there again, you might want to keep the press release that somebody has been prosecuted, but you might have a separate retention criteria or deletion criteria when, you know, say for example, when the crime is spent or when the press have finished with the press release. Yeah? That's an area where perhaps the right to be forgotten might apply also in that sort of bit, the press release thing. Yeah? But
and I'm conscious of an example where, for example, for information about foster carers, we have to hold their records for 75 years, the law says. And so as a consequence, I assume that we have to hold their personal data for under protections of the GDPR, but nonetheless.
It's necessary for your functions. So basically, look at the Article 6 grounds. Why are you keeping it? Yeah? If you haven't got the Article 6 grounds, you're going to fall at the fifth principle, no longer than necessary.
Yeah, Councillor John Bevan from Haringey. I'm quite new to this subject, so the right to be forgotten has just been mentioned. Can that be expanded, a bit more information about that?
Okay, the right to be forgotten mainly applies for information placed in the public domain by the data controller. You know, for example, somebody posts some stuff about yourself and it's linked, indexed. So it's not the individual about whom the information relates is posting it, it's somebody else is posting it about you, right? And they're making it public. That's where the right to be forgotten. Now, if I ask, where does the local authority publish information about an individual? Yeah? Very rarely. Perhaps we say there might be stuff linked with FOI requests to personal data, but most of those cases, I suspect that there's a refusal for publishing personal data about individuals. Yeah, I might ask, for example, an FOI request is, can I have a copy of your phone book? What would you do in FOI? You refuse. You've already published it to your local authority staff. Anyway, we can argue that one offline. But the first criteria, going back to the question, the right to be forgotten, the information has to be put into the public domain by the controller, and I can't see many areas where you would put personal data in the public domain except in a press release, which is the obvious area about benefit fraud. Yeah?
My name is Robert Bishop from Woking Borough Council. My question is about the practical implications for IT, for GDPR, and what constitutes necessary organisational or technical measures. We're migrating to a new version of Microsoft SharePoint, and I was asked by the person bringing it in projects to how we should organise access restrictions on different libraries. And the question posed is really, do you, on each library, do you keep the access to just the people who are in the team for that library, or do you open it up for everybody and rely on no one to use it wrongly? I'm just looking for advice on what the answer to that question is, because I'm relatively junior in my organisation and I don't have the experience to really reply to it.
I don't think any of us could say what you should or shouldn't do. It's horses for courses. I think you need to make that decision. It will come down to your business need, how strong your policies are, how well trained your staff are, what your risk appetite is. It's not something that I would say I could make a judgment on. Sorry.
It's a very good example of the conversations that are being had on the knowledge sharing group. And we'll give you the link in a short while, but there's conversations, a council or a person asks the question and someone chips in, and then when you look a week or two later, there's 20 or 30 people conversing on this and coming down and homing down to some sort of an opinion. But ultimately, it's your responsibility as an organisation, as Laurie said, to set the policy and have reasonable evidence as to why you came up with that policy.
Hi, I'm Yemi from Runnymede Borough Council. My question is more about the practicality of how the replacement for the Section 29 request would go into place from the 28th. Like, assuming that the Section 29 can't be quoted anymore, what would be the correct? Is it by the Data Protection Bill or Section 1, Schedule 2?
It has to be the Schedule 2 exemption, because the Data Protection Act's gone. The legislation finishes, it's repealed, defunct, dead, gone, bye-bye. Right? Yeah? So you've got to go to the new legislation, and that's the reason why I said it'd be very useful for you to familiarise yourself with where things are in the current arrangements, so you know roughly where they are. That's not going to change. You might find there's slight wording changes, but in effect, the substance is not going to change.
But seeing as the onus would be on the organisations making the request, how can we know that they would be quoting the right section?
Well, if somebody quotes the wrong section, you don't disclose. Okay, I mean, okay, so just give an example. I was faced with somebody, a local authority who will remain nameless, but if somebody plies me with booze, I'll be most indiscreet, okay? Right, the local authority basically said, you're required to disclose this information under the Social Security Administration Fraud Act, Clause 212, Section 212. So what do? I look at Section 212, and it's nothing to do with disclosure, but Section 221 seems to fit the bill. So what do? Do I disclose or not disclose? So I'm not disclosed in a polite way, okay? And Section 212... or whatever it was, started off, 221 started off, an inspector appointed by the Secretary of State. So I sort of put in the letter, if perchance you're an inspector appointed by the Secretary of State, can I see your appointment details? Yeah? And I got a fax back saying, sorry, I've got the wrong section, it's 221, typo. Right, okay, yes, okay. And his warrant card said appointed under the Secretary of State under Section 87 of the Social Security Administration Fraud Act. So what do? Now, Section 87 has nothing to do with appointments of inspectors, but Section 78 seems a bit Right. Do I disclose? Right, same letter went back. I got this shirty fax back. Did you know it's an offence to obstruct an inspector in the course of his duty? So, two of us can play that game. Did you know it's an offence to obtain personal data under false pretences? Right, okay. Lots of local authorities, a lot of public bodies exercising powers don't exercise them properly. Certainly in this area of what used to be Section 29, you know, if they don't exercise their powers properly, I wouldn't disclose to them. They've got to do it properly. Yeah? And they've got to do it properly in a form that basically satisfies you. Remember, Section 29, as well as the one in Schedule 2, is a voluntary disclosure. There's no obligation for you to disclose. So if they don't exercise their powers properly, or if they don't convince you that failure to disclose would prejudice the crime, then I wouldn't disclose. I'd just say, look, I can't see how I'll link it with the legislation. But going back to the basic thing, you need to basically find out where things you use are in this legislation. Yeah? Because then when you get the real act, i.e. in 2 months' time, 3 months' time, you know where things are and you can read it carefully. But just find out where things are.